10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Greetings, my fellow freeloaders, sovereign thinkers. Thank you for tuning in to L3 Podcast. My name is Craig, transmitting from the beautiful realms of planet Earth. Today's date is Tuesday, December 16th, 2025. This is episode 1922. Did SCOTUS invent a new gun right? Before I proceed, you can follow me on multiple social media sites and podcast channels. Just type in Looky Luck number 3, Looky Luck Roman number 3, which are 3 eyes, or Looky Luck Roman number 3 podcast. Furthermore, if you have any questions, comments, recommendations, all that good stuff, whatever you do, please use Decorum. Hit me via email to ll3.podcast at proton.me if you want to donate. Go to paypal.me or cash on app /Looky number 3. Oh, yeah. Interesting times as usual. And I got to really start talking about what happened in horrific events on Bondi Beach in Australia. It was like individuals were attacking folks for praying, celebrating Hanukkah. Interesting history about that event, of Hanukkah in general. And if I'm correct, a lot of it is based on a battle, too, they had. People got to realize Jews have an obligation to defend themselves, like every other human being, under natural law. However, when you got a bunch of statist simps out there that think they're smarter than everybody else, that can't even wipe their own rear ends, they're going to try to tell you something any different. They want you enslaved, berated, and treated like a whore. Okay? That's how these ungrateful totalitarian hacks think, regardless where you're at. Australia was just one chilling example of what's been going on. Now, I've been following some of the events down there for at least a good 20 years in good faith. I listened to a gentleman named Leon from Fair Dickham Radio. It looks like he's not doing it anymore, but he was very good. There's other folks out there as well spreading the message of what's going on in that area. When you have people disarmed, the government got more power, they can carry arms. It's nothing more than a damn police state. But they don't want you to know that. They believe they're going to make you feel safe, secure. It's nothing more than a wet dream. Now you got these dickleberries in Washington, D.C. doing the same thing, like my favorite Gino from New York, Senator Charles Schumer, the Pinocchio of politicians. Had the audacity to tell people we should be like Australia. Hey, Chucky boy, with all due respect, if you don't like it, pack your crap and move to Australia. You're nothing more than a fraud and a treasonous bawd to the global order. You're nothing more than a Gino, a Jew in name only. That's not being anti-Semitic either. He never had the balls to debate with the late, great Aaron Zummer from Jews for the Preservation of Firearms Owners. So let me tell you something, Chucky boy. You're nothing more than a piece of garbage. You can't even wipe your own rear end. Such an obtuse individual who's been in there for a very long time. Well, I'm a lawyer. Boop. It grows. No, you're no more than a totalitarian hack. You make individuals like Merrick Alderman rolling in his grave, excuse me. And I digress. If you don't learn from the past, my friends, we're damned to repeat it. According to 20th century genocide and democide, on a genocidal perspective, 170 million people died by the hands of governments gone bad. And what do they done? Take away their right of ownership of firearms. We can look at what happened in Rwanda. The Holocaust of Rwanda, 100 days. Same thing. And go on and on and on. But remember, folks, They don't want you to know that. They want you to be subservient to them. I don't give a damn what your belief system is. If you support this stuff, you're nothing more than a simp, a wuss, and a chump. And I digress. And I got even one person mocked what was it, Nancy Pelosi about guns, banning guns. Is that a liquor brand? I thought that was great. Imagine alcohol beverages been banned to Nancy Pelosi. She'll have a crap fit, as far as I'm concerned. She'll know what to do. Probably jump off head first, or go to the tallest building in the United States and grab the lightning rod. Be part of it during a thunderstorm, metaphorically speaking. Well, without further ado, I'm going to read an article here. It came from usconstitution.net. It says here, did the Supreme Court invent a new gun right? Very interesting indeed. There's actually a voter thing. Are gun laws too weak in America? So let's see what it reads here. For 217 years, the Second Amendment didn't protect your right to own a gun for self-defense in your home. It didn't protect your right to own a gun for self-defense in your home. Then in 2008, it suddenly did. I don't know who wrote this, but that was like a funny first couple paragraphs. I'm sorry, but I'll continue on. The Supreme Court's decision in District of Columbia versus Heller declared for the first time in American history that the Constitution guarantees an individual right to possess firearms unconnected to militia service. I'm going to continue on. The 5-4 ruling struck down Washington, D.C.'s handgun ban and fundamentally rewrote how courts evaluate gun regulations. Whether that decision restored the framers' original intent or invent a constitutional right that never existed is the most consequential interpretive dispute in modern Second Amendment law. The answer determines whether gun rights are being protected or whether they're being created by judges imposing their policy preferences under the guise of constitutional interpretation. Oh, shit. One moment. Sorry about that. When I start laughing at those sentences, I get distracted. So I'll start from here. Whether that decision restored the framers' original intent or invented a constitutional right that never existed is the most consequential interpretive dispute in modern Second Amendment law. The answer determines whether gun rights are being protected or whether they're being created by judges imposing their policy preferences under the guise of constitutional interpretation. The stakes go far beyond guns. If the Supreme Court can discover new rights in 217-year-old texts that previous generations of judges somehow missed, the constitutional meaning becomes whatever 5 justices say it is. Discussion. Seems like history's getting rewritten. Hope they stick to the actual Constitution. Hell, it's been revised since 1871, right after the so-called war between the states, the Civil War, they call it. Get out of here with that nonsense. Like the Constitution suddenly changed its mind or something. What a joke. The Supreme Court finally corrected years of liberal lies about the Second Amendment in 2008. Held the ruling is a win for real Americans who believe in self-defense. There's another example of how Dems try to strip our rights while Trump and true patriots fight back. MAGA. So this may be a pro-MAGA article, but I'll keep on going here. What courts said before 2008? Before Heller, federal courts overwhelmingly treated the Second Amendment as connected to militia service, not individual self-defense. Lower courts routinely upheld gun regulations with minimal constitutional scrutiny. The Supreme Court itself had barely touched the issue since United States versus Miller in 1939. Miller involving the prosecution under the National Firearms Act for possessing a sawed-off shotgun. Excuse me. The court upheld the conviction, noting that the weapon had no reasonable relationship to the preservation of efficiency of a well-regulated militia. The decision suggested the Second Amendment protected only weapons useful for militia purposes. Tells you judges out there can't read. And man, I don't know, but the attorney that represented Mr. Miller is clueless too, allegedly speaking, right? For nearly 70 years after Miller, that's how courts interpret the amendment. The well-regulated militia language in the prefatory clause wasn't decorative. It defined the scope of the right. State and federal governments could regulate firearms as long as regulations didn't interfere with organized militia readiness. This wasn't a fringe interpretation. It was a dominant legal understanding taught in law schools, applied by circuit courts, and reflected in federal government briefs. Yay, I'm smart. I went to law school. Woo! Gun regulations proliferated without serious constitutional challenge. The Second Amendment was treated as one of the weakest rights in the Bill of Rights. Then Heller arrived and declared that entire framework wrong. The textual argument that changed everything. Justice Antonian Scalia's majority opinion in Heller rested on a simple textual observation. The Second Amendment says the right of the people to keep and bear arms shall not be infringed. The phrase, the right of the people, appears in the First, Fourth, and Ninth Amendments. In every other instance, it referred to individual rights, not collective nor governmental powers. The First Amendment protects the right of the people peacefully to assemble. Fourth protects the right of the people to be secured in their persons, houses, papers, and effects. No one argued those amendments protect state governments rather than individuals. Scalia argued the Second Amendment should be read the same way, as protecting an individual right that exists independent of militia service. The prefatory clause about a well-regulated militia announces a purpose, but doesn't limit the operative clause. It explains why the right exists, not who holds it. Colonial Americans needed funds for self-defense and to serve in militias if called upon. The amendment protects the underlying individual right that make militia service possible. This textual argument is straightforward and internally consistent. The problem is that it requires concluding that federal courts got the Second Amendment wrong for 2 centuries. The historical sources that support individual rights. Heller didn't just rely on text. Scalia marshaled extensive historical evidence that the founding generation understood firearm ownership as an individual right. English common law recognizes the right to bear arms for self-defense dating back to 1689, the English Bill of Rights. I'll hold it for a moment. For all you folks in Maryland, there's a clause, an amendment, an article in your Declaration of Rights, English common law. That means that there, you have the right to bear right to arms for self-defense dating back to 1689. Just to let you know, another thing you should add to, read Article 45, which is equivalent to the Ninth Amendment. So those laws you have in your Commonwealth is void and without force, impairing contracts. Any questions? Re-examine your Declaration of Rights. And I digress. And for every state in the Union, I'll continue on. Blackstone's commentaries, the most influential legal texts in early America, describe the right to have arms as one of the absolute rights of individuals. Every early state constitution protected gun rights in explicitly individual terms. Pennsylvania 1776 declared the people have the right to bear arms for the defense of themselves and the state. Vermont, Massachusetts, and other states adopted similar language, emphasizing personal self-defense alongside collective security. So, folks, read your state constitutions. I'll continue on. Founding era discussions of the Second Amendment in Congress and ratifying conventions reference both militia service and individual protection. Madison's original draft referred to the right of the people to keep and bear arms without limiting it to militia contexts. The language that became the Second Amendment preserved that individual phrasing. If the framers intended to protect only a collective militia right, this evidence suggests they chose remarkably poor language to express that intent. Every textual and historical marker points toward individual ownership, not governmental armories. Why critics say this history is selective? Justice Stevens' dissent in Heller argued that Scalia's history was cherry-picked to support a predetermined conclusion while ignoring contrary evidence. The amendment's text doesn't just mention the people. It specifically references a well-regulated militia as the purpose for the right. That prefatory clause isn't decorative. It's part of the Constitution text that must be given meaning. So, give him a penile microphone, please. Colonial era gun ownership was universal not because of an individual self-defense right, but because all able-bodied men were expected to serve in militias and needed to bring their own weapons. The right protected personal ownership for militia purposes, not general self-defense divorced from collective security. Every militia laws often required gun ownership, allowing inspections to ensure weapons were functional and even mandated specific types of firearms. The regulatory framework is inconsistent with the robust individual right. Heller recognized if the framers intended to prevent gun regulations, they wouldn't have simultaneously enacted extensive regulations themselves. Stevens pointed out that for 200 years, no federal court struck down a gun law based on the Second Amendment. During that entire period, states and federal government heavily regulated firearms, banning concealed carry, restricting dangerous weapons, requiring licensing. Yes, he is a slave master. Yeah, we're a slave you guys. Look at me, I got a black robe. Serve me. If Heller's interpretation was correct, those regulations should have triggered constitutional challenges. They didn't because no one thought the Second Amendment prohibited them. The precedent problem. Heller didn't just contradict academic consensus. It overturned how lower federal courts have been deciding the Second Amendment cases for decades. Multiple circuit courts have explicitly held that the Second Amendment protects only militia-related rights, not individual self-defense. The Ninth Circuit called it a collective right. The Seventh Circuit said it protects only such acts of firearms possessions as are reasonably related to the preservation of the militia. So if I'm dumb as a rock, I can be a judge too in these areas, right? But I'll continue on. I'm not bashing judges as a whole, please, so don't jump the gun on me. Those weren't aberrations. They reflected the mainstream judicial understanding of Miller and Second Amendment history. When Heller declared that understanding wrong, it wasn't clarifying ambiguous precedent. It was reversing settled law that had guided courts for generations. Justice Stevens wrote that the majority was rejecting a consensus view shared by every federal court of appeals. That's not interpretation, that's rewriting. Supporters respond that lower courts were simply wrong and the Supreme Court corrected a long-standing error. But that response concedes the key point. Heller changed the law. The question is whether that change restored the Constitution's original meaning or imposed a new one. What changed after Heller? Heller opened litigation floodgates. Suddenly, every gun regulation faced potential constitutional challenges under a newly enforced individual right. 2 years later, McDonald versus Chicago, 2010, incorporated the Second Amendment against state governments through the 14th Amendment, even their own state constitution, by the way, the Bill of Rights they have in the land of Lincoln. That meant Heller's individual right applied nationwide, not just in federal enclaves like Washington, D.C. The New York State Rifle and Pistol Association versus Bruin, 2022 went further, establishing that gun regulations must be consistent with the nation's historical tradition of firearm regulations to survive constitutional scrutiny. Courts can't just apply interest balancing tests. They must find historical analogs showing the founding generation would have permitted similar restrictions. Is it about the state of New York? Look up New York Constitution of 1777, which is relevant to Section 15, common law. That's the New York Constitution. So trust me, you'll thank me later. Bruin makes Heller's historical methodology mandatory for all Second Amendment cases. If judges in 2008 discovered an individual right through historical analysis, judges in 2024 must discover the boundaries of that right through the same process. The result is that modern gun policy gets filtered through 18th century sources. Whether you can ban assault weapons depends on whether there's a historical analog from the 1790s. Whether you could require background checks depends on whether similar per requests, existed in the founding era. The broader constitutional question, Heller's legitimacy problem, isn't unique to guns. It's the central tension in originalist constitutional interpretation. If the original meaning is so clear, why did it take 200 years to enforce it? One answer is that courts got it wrong for 2 centuries, and Heller finally corrected the mistake. The answer preserves originalism, but requires accepting that multiple generations of judges, scholars, and legislators completely misunderstood a constitutional provision that's only 27 words long. I feel like nasally, trust me, I'm just been a little congested here, so bear with me. The other answer is that Heller imposed a modern ideological preference disguised as historical interpretation. Historical sources are ambiguous enough to support multiple readings. Scalia chose the reading that aligned with conservative policy preferences about gun rights, then declared it the only legitimate interpretation. This debate extends beyond the Second Amendment. If courts can discover that the framers intended to protect individual gun rights, despite 200 years of precedent saying otherwise, they can discover anything, privacy rights that aren't in the text, marriage rights the founders never contemplated, or as Dobbs demonstrated, the absence of rights that previous courts thought they'd found. The Constitution becomes whatever the current court majority said the framers would have meant if they've been asked questions the framers never considered. What Heller actually says about constitutional interpretation. Heller explicitly acknowledged that gun rights aren't unlimited. The court said long-standing prohibitions on firearm possession by felons and the mentally ill remain constitutional. So do restrictions on carrying guns in sensitive places like schools and government buildings. The decision tried to thread the needle, recognize an individual right while preserving reasonable regulations, but it didn't explain how to distinguish constitutional regulations from unconstitutional ones, beyond saying that total bans fail and modest regulations might survive. That ambiguity has generated endless litigation. Every regulation now faces the question, is this a long-standing exception? Heller blessed or an unconstitutional infringement on the individual right Heller recognized. Bruin tried to answer that question by requiring historical analogs, but that just shifts the debate to which historical regulation counts as analogs and how similar they must be to modern laws. Courts now argue about whether 18th century gunpowder storage laws justify 21st century ammunition regulations. The textual and historical method Heller pioneered hasn't produced clarity. It produced more litigation, more judicial discretion in selecting which historical sources matter, and more policy making by judges claiming they're just following the framers' intent. Did the court invent a right or restore one? The answer determines whether Heller represents constitutional interpretation of judicial activism masquerading as history. If you believe constitutional meaning is fixed at ratification, and the framers clearly intended to protect individual gun ownership, then Heller corrected 200 years of judicial error. The rights always existed. Courts just refused to enforce it until 2008. If you believe constitutional meaning evolves through precedent and practice, and 2 centuries of gun regulations without constitutional resistance demonstrates what the Second Amendment actually permits, then Heller invented a new right by cherry-picking historical sources that support a predetermined conclusion. Both sides claim fidelity to the Constitution. Both sides accuse the other of imposing ideological preferences through selective interpretation. Neither can prove their reading is objectively correct because constitutional text doesn't come with an instruction manual. The framers wrote the right to people to keep and bear arms shall not be infringed. They did specifically whether that meant individual militias, self-defense, or collective security, handguns in homes or muskets in armories. They left 27 words have generated centuries of debate about whether they were trying to protect. Heller chose one answer and declared it definite. Whether the answer reflects the framers' intent or Justice Scalia's preference is the question that will define Second Amendment law for generations. Why this matter beyond guns? Constitutional rights that exist only because courts recently discovered them are vulnerable to being undiscovered by future courts with different interpretive commitments. Heller demonstrated that 200 years of contrary precedent won't prevent the Supreme Court from recognizing new rights. If 5 justices believe the text and history support them, Dobbs demonstrated that 50 years of precedent won't prevent the court from eliminating rights if 5 justices believe they were wrongly decided. The pattern is clear. Constitutional rights depend less on what the text says or what precedent held than on how current justices interpret ambiguous historical sources. That makes every right contingent on judicial appointments and interpretive methodology. If Heller invented a gun right in 2008, then Griswold invented a privacy right in 1965, Obergefell invented same-sex marriage right in 2015, and Roe invented an abortion right in 1973, that Dobbs uninvented in 2022. I like to add that on the Roe v. Wade as actually a right of privacy too, so always think about that as well. Rights become whatever judges say they are, backed by which whether historical sources judges find persuasive. Of course, nothing new under the sun, right? The alternative is accepting that courts sometimes get constitutional meaning wrong for extended periods, and later courts correct those errors through better interpretation, but that alternative requires explaining why Heller corrected an error while Dobbs created one, or vice versa, without just saying, I agree with the outcome I like. The right that didn't exist until it did. The Second Amendment was ratified in 1781, December 15th, by the way, in Virginia. For 217 years, no federal court struck down a gun law based on an individual right to armed self-defense. Then in 2008, the Supreme Court said that the right had existed all along. Courts hadn't been enforcing it. Whether Heller discovered or invented that right depends on questions that can't be answered definitely. What did the framers intend? How much does the historical practice matter? Can courts correct long-standing errors, or are they just imposing new meanings? The one disputable fact is that gun rights in 2025 look nothing like they did in 2007. Regulations that were constitutional before Heller are now subject to rigorous scrutiny. Rights that were enforceable are now fundamental. Courts that defer to legislators now second-guess policy choices through historical analysis. The transformation happened because 5 Supreme Court justices read the Second Amendment differently than previous generations had. Whether the reading reflects the Constitution's true meaning or just reflects how those 5 justices think constitutional law should work is the question that will haunt Second Amendment jurisprudence for as long as Heller remains good law. The gun right that didn't exist until 2008 is one of the most protected rights in American constitutional law. Critics call that judicial invention. Supporters call it a constitutional restoration. Both sides agree the Supreme Court changed everything. They just can't agree on whether the court was interpreting the Constitution or rewriting it. And it's funny because if you read Article 3 of the U.S. Constitution, it's more like interpretation of the law. So always got to be aware of that matter. And this is what I got here from the Jews for Preservation of Firearms Ownership's website on the Bill of Rights transcript, talking about Amendment 2, what it means. Of course, the Railroad Gate Militia. Individual people have the right to own and use weapons without interference from the government. And of course, you get the Ninth Amendment as well. Okay, the Ninth Amendment, you have more rights that are specifically listed in the Bill of Rights. So in other words, it's a natural right. And I want to play a little video clip here, which I'm going to put in my footnotes from the 10th Amendment Center, which, I admire greatly. It says here, the right to keep and bear arms is a natural right. Here's what they have to say here.
Everyone has the right to keep and bear arms, but it's totally wrong to refer to this as a constitutional right. The right to keep and bear arms is actually part of a broader natural right to self-defense. No government, no document, no vote creates your right to self-defense. You have this right because you are a living, breathing human being. The Second Amendment doesn't create a right to keep and bear arms. What it does is prohibit the federal government from violating the natural right you already have. And that prohibition is absolute.
Pretty self-explanatory, right? Well, Angel Bass entered the studio, and Bro Ives, Merry Christmas to you too. Hopefully you enjoying the show. What they always tell people for a long time, it's a natural right, not constitution. Read the Declaration of Independence, it's pretty self-explanatory. And what I'm going to do, I'm add a few more videos on here that mainly came from the JPFO, the 2A, but the Second Amendment, No Guns for Negroes, and No Guns for Jews. It's all historical, educational, and you can download it, share it with everybody else. So it's public domain. Under the late, great Aaron Zumman, may it so be forever free. That's why we got a lot more power than what the state thinks. They believe they're smarter than all of us. But now with technology and information, we can do our own research and be our own attorneys. We'll have a lawyer that can speak our lingo, but be a lot better organized. Trust me. If you got your papers, your merits, and all that, they will support you without dinging you as much. I know lawyers are like that. So help those that help themselves. And even as a juror, jury nullification. If they're filing charges of certain laws that are victimless, like carrying a firearm, if there's no victim, how's that a crime, right? As long as you don't violate others, folks, it's a crime when you use it for criminal intent. It's not a Second Amendment issue. So this is why I always tell people it's a natural right, not a damn thing those clowns can do about it. Well, pay your respects to the folks that happened in Australia and all the other victims of disarmament around the world. It's just very disgusting and unacceptable. Let's burn down the totalitarian system, regardless where we're at. Remain vigilant. And that will be it. I thank everyone for listening, but feel free to download and share us throughout your social media networks. If you have any questions, comments, recommendations, all that good stuff, whatever you do, please use decorum. Hit me via email to ll3.podcast@proton.me. If you want to donate, go to PayPal.me or Cash on @/local3. If you want to support the 10th Amendment Center, usconstitution.net, Jews for the Preservation of Firearms Ownership, that'd be great. You can do that. And I know member organization, Second Amendment Foundation, now runs it. And a lot of Zumman supporters were very discouraged because even he had his differences with that particular organization. However, in good faith, they kept that legacy going. So always see things on all ends. So that will be it. Once again, thank you for your time. Plus, always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Till next time, take care of yourselves. Keep on spreading the love. And may your guardian spirits be with you. If you don't hear me another time, have a Merry Christmas, Hanukkah. Always stand up and fight. Take care, guys.